Hi, everyone. My name is Rebecca Lopez-Chris. I'm with the Philadelphia Department of Revenue. If you're joining us, you are watching a video that is the third installment of a series that the Department of Revenue is doing about Philadelphia's tax structure and its federal and state law constraints. So we've got a few other videos to check out, including an intro to Philadelphia taxes and also a deep dive into the business income and receipts tax. So if you're super nerd-tastic, you can definitely dive into that. Today, we're getting really nerdy with our chief counsel, Frances Beckley. That means she's my lawyer. So Frances represents the Department of Revenue, and she helps make sure that we understand the law, because I think a lot of people think that, well, the city can just do what it wants. If it wants to pass legislation, it can just do that. And the reality is we can't. We're governed by a lot of federal and state laws about what we can tax and how we can tax it. So that's what Frances and I are going to talk about today. Okay, so we're going to start with kind of a brief introduction to what the powers of the city has and what laws gave us that authority. Also kind of the organization and the duty of city government. And then we're also going to talk about some of the federal law limitations, and then a number of state law limitations that really are very, very strict, that we, people want us to do certain things. They would like us to be able to do a certain thing. And there's just these things in the state constitution and the state law that makes it so that we're not able to do those things. And to make the point even further, we're going to talk about a few examples of very well-intended legislation here in Philadelphia that just didn't pass some of those legal hurdles. Okay, so let's get started. Frances, let's start by talking about the relationship between the city and the state. Can you give us a brief overview of how we came to have the powers we have today? And for folks who are watching at home, we've got the slides here so you can follow along. We'll also be providing copies of these slides and copies of kind of the talking points from this presentation. So you don't have to scribble furiously all your notes, but because Frances is going to get into some very, very specific legal nitty-gritty. Okay, Frances, take it away. I'm sorry, I didn't mean to hop in there.
All good. So in 1949, the Commonwealth passed the Home Rule Act, which gave lots of independence and lots of power to Philadelphia, but notably, one of the powers it did not give the city is the power to tax. In 1951, Philadelphia passed its Home Rule Charter, also called the City Charter. This charter made multiple changes, such as giving City Council more legislative power, requiring public hearings on ordinances, and creating the Philadelphia Code. The same year, the city worked with Pennsylvania to amend the Constitution to allow Philadelphia to consolidate its city and counties. And we are the only jurisdiction in the Commonwealth that has consolidated city and county government. That consolidation gives us lots more power. We have many functions that belong to the county, but it also gives us lots more responsibilities and obligations. We have to pay for things like the courts and the jails and social services that in most of the Commonwealth are the province of the counties.
Right, and normally in any other kind of in any other area, some of those services would be supported by neighboring jurisdictions who are all part of the county. But because we're one and the same, we've got a lot more on our plates. So Frances, you mentioned specifically the Home Rule Act. You said that it excluded taxation from the powers given to the city. Can you tell us more about what laws give Philadelphia the authority to tax?
Certainly, there are a few laws that are particularly significant for Philadelphia. Probably the most significant is the Sterling Act, which gives us the power to tax everything that isn't taxed by the state. However, also important are the General County Assessment Law, which gives us the power to tax real estate, and the First Class Business Tax Reform Act.
Right, and we're able to do this because we're a city in the first class, which means we have more than 1.5 million residents. We're the only city of the first class in Pennsylvania, and that makes us special, right?
That's right, and it's a little funky, and because in the Pennsylvania Constitution doesn't allow you to make jurisdiction-specific tax laws. So they can't say Philadelphia can tax this. They have to say cities of the first class. And the legal fiction is that some other city can get enough population to also become a city of the first class. But the reality is when you see city of the first class, it means Philadelphia.
Right. You never know, though. You never know.
Pittsburgh could take off.
Right. And we hope that they do. Okay,
Exactly.
So what about taxes that support the school district? So there are separate laws. What are the separate laws that authorize those tax types?
Well, the school district gets its funding, of course, also from the federal government and the state government. But the Philadelphia funding from the school district has basically three main sources. There is the Little Sterling Act, which allows the school district, with the support of city council, because since the school district board members are not elected, they can't have direct taxing authority. So school district taxes have to be authorized first by city council and then passed by the school board. So the Little Sterling Act is the source of the school income tax and the use and occupancy tax. The school district also gets a portion of the real estate tax. And there is a separate law that passed that supports the liquor by the drink liquor tax, that is the fourth school district tax.
Right. And we are, for whatever, we don't have to get into it, but we are forbidden to use amusement tax revenue for the school district. That's just, I'm sure,
sort of a random thing in the state
quirk
law.
of the legislation. Exactly. Okay. So now that we know what laws authorize Philadelphia taxes, we should talk a little bit more about how those laws limit what we can and cannot tax, as well as how we tax certain items. Okay, so we're going to start with the federal limitations. So what should people be aware of when it comes to federal laws and the city's tax structure?
Okay, so we can't, for obvious reasons, just impose tax on somebody doing business in California who has no connection with Philadelphia. And that limitation is, when we point to why that's the case, we point to the Due Process Clause of the federal Constitution that says that in order for Philadelphia to tax a business, the business has to have, quote, purposefully availed itself of the Philadelphia market. You have to be trying to sell stuff to people in Philadelphia in order to be subject to Philadelphia business taxes. Similarly, the federal Constitution preserves to Congress the ability to regulate commerce between the states. And a part of a subset of that prohibition is that states may not treat non-resident businesses less favorably than businesses that are located within the state. Finally, the federal government, in response to some Supreme Court cases that it did not like back in the middle of the last century, passed something called Public Law 86-272. This prohibits net income taxation of an entity selling tangible personal property if the only connection that business has to the jurisdiction is soliciting within the jurisdiction and sending its goods in by public common carrier.
Right. So like someone who's not located in Pennsylvania
just sells widgets and
but is selling candles, selling candles online through the mail. That's different.
Right. But notably, it only applies to taxes that are net income taxes, which is why it does not apply to the gross receipts portion of the business income and receipts tax, which has been very confusing for a lot of out-of-jurisdiction taxpayers. Finally, there's another federal law that restricts business tax on commerce called the Internet Tax Freedom Act. That prohibits any tax on internet access except for those that were grandfathered before that law was passed in, I've forgotten. I think it was in the 80s.
I think it's pre-1998, right? Anything that's before 1998.
And also prohibits any tax on internet commerce that is less favorable than taxes on other commerce. And this is an issue right now. Maryland has tried to pass a tax on internet advertising, and one of the claims of the internet companies that that this tax is illegal is that it violates the Internet Tax Freedom Act, because it's only on internet ads. It's not on ads in magazines and newspapers and other forms of communication.
Well, we'll follow that closely.
We definitely are.
So next are some of the biggies with state limitations. This one is really big, the uniformity clause. What do folks need to know here?
The uniformity clause says that taxes on members of a single class have to be the same. So the big question always is, what is a reasonable class? How can we slice and dice the tax of all the class of all taxpayers into subclasses for different taxation? And there are two ways in which the Pennsylvania courts have interpreted this much more strictly than courts in other states that have interpreted pretty similar language. The first way is that the Pennsylvania courts have held that all real estate is a single class. You can't tax commercial real estate and residential real estate differently. You also can't have, for example, tax credits against real estate tax that depend on the use of the property. The other big way that Pennsylvania courts have interpreted this is to say that size or income is not a reasonable basis for class. That means that if we pass an income tax, it has to be the same on Bill Gates as it is on a sanitation worker, which is more than a little counterintuitive to most of us. $1 to each of those people is not really the same thing.
Right, and it's also not how the federal government does it, right? The federal government has a progressive income tax. And so that's the big question. People are always like, why can't Philadelphia have a progressive wage tax? And the answer is uniformity, right?
Exactly. And we thought that perhaps things were sort of lightening up a bit in this area. And then in 2017, the Pennsylvania Supreme Court came out with the Nextel decision, which had to do with capital gain net operating loss carryforwards, but which reaffirmed that no way, no how are we going to allow you to treat taxpayers differently based on size or income.
Okay. So, but there are some exceptions that are built into the state law.
Well, in the Pennsylvania Constitution actually has provisions that are exceptions to uniformity in the Constitution. And unless there is one of those exceptions, even the General Assembly can't mess with uniformity.
Wow. Okay. So can we talk about the uniformity clause in institutions of purely public charities? I know that that's a big question and that comes up a lot in Philadelphia.
And there's been a tremendous amount of litigation over what is a purely public charity. A purely public charity for purpose, and in Pennsylvania, if you are a purely public charity, you are exempt from both real estate tax, which is obviously huge, and also from sales and use tax. The standard for what is a purely public charity for this purpose is much higher than it is for the Internal Revenue Service. Many people assume that just because an organization has 501c3 status from the IRS, it will be a purely public charity, and that's not in fact the case. Because there was the standard for what is a purely public charity for constitutional purposes was set by the Pennsylvania Supreme Court in 1985, and it's referred to in a case called Hospital Utilization Project, and you'll hear people refer to what is called the HUP test, and that's the HUP test. Okay, people continued to litigate. Even with that guidance, it was still pretty unclear in many cases whether whether an organization qualified. There was lots of litigation. The General Assembly got fed up with that. They said, we're gonna put out a law that has clear standards for who is a purely public charity. And they did that in Act 55 in 1997. However, litigation continued, and the Pennsylvania courts made it clear that while it's fine to have a statutory standard, and the General Assembly is authorized to create the exception for purely public charities. So there's no question that they have a right to say for statutory purposes who's a purely public charity. Only the courts can say for constitutional purposes what is a purely public charity. So you don't even reach the statutory test unless you've passed the constitutional test.
But pilots are not an uncommon thing. We do set them up.
Absolutely. And in fact, every business that sets up in a Keystone Opportunity Zone must make a pilot as a condition of getting its KOZ benefits. So, that drives a lot of that business now.
Okay, so we'll keep moving here. Apart from exclusions to uniformity, can you tell us more about the situations in which the clause allows us to separate tax rates?
Okay, well, there are, again, the only time that is authorized is if there is something you can point to in the Constitution. However, the Constitution includes a lot of exceptions. For counties of the first and second class only, relief programs may be established for longtime owner occupants. And you may have heard about this. We call it our LOOP as the acronym for longtime owner occupant program. Who live in the areas where real property values have risen due to new construction or improvement of other properties. Remember, Philadelphia is the only county of the first class in Pennsylvania. Second, homestead properties can also have a separate tax rate. So that's where we get the ability to, and the General Assembly has passed authorizing legislation allowing us to have homesteads. However, there are a limitation on having exclusions for homesteads is that the homestead exclusion cannot generally be raised in the same year that you raise the income tax rate, because the exception specifically prohibits paying for an increase in homestead exclusion with an increase in tax rates.
Right. So just to reiterate that, we can reasonably interpret this to mean that Philadelphia generally can't increase the size of the homestead exemption and, let's say, the real estate tax in the same fiscal year. Just generally, we're probably not going to be allowed to do that.
Correct. You'd have to be able to point to another tax that you're using to pay for the increased homestead exclusion.
Okay. And so keeping on, like there are separate tax rates for, let's say, for because of age or disability or income. Let's say they're very low income. We have special tax provisions for those folks, don't we?
We do, and that's because there yet another exception in the Constitution's Uniformity Clause allows for the creation of, by the General Assembly and only by the General Assembly, of special classes based on age, disability, infirmity, or poverty. And that's where, for example, you may be aware that at the very lowest income level, the state's personal income tax doesn't apply to people. There's an exclusion there. What this means is every time the city tries to pass legislation that includes a poverty class, we need to look to the state standard of what constitutes poverty. And that's why, for example, you'll see our senior tax freeze program look to the state prescription drug benefit to say who is poor.
Right. We use a state standard for eligibility for those programs.
Right.
Okay, so we have the Uniformity Clause. What other state limitations exist?
Well, going back to the fact that the city has no inherent taxing power of its own, it needs to look to the Sterling Act for the vast majority of its power. And the Sterling Act is pretty close to tax anything within Philadelphia. The only thing that you cannot tax that happen within the city are things already taxed by the state. That's a pretty significant limitation. And people may remember that was a huge issue when we passed the beverage tax, because there was a claim by the soda manufacturers that was duplicative of sales tax and therefore preempted. But of course, we won that case. and they aren't.
Right. The Supreme Court of Pennsylvania disagreed with that assertion. But I mean, we're enabled to have a host of taxes, including parking, valet, amusement. We have a lot. I mean, even though we're talking about the limitations, we still have a pretty diverse set of taxes. Okay, so you mentioned in some aspects with the Sterling Act limits what we can do. Do you want to talk a little bit more in detail? Like let's say specifically around wage tax and non-resident wage tax.
Right. There's again, when you get all your power from the state can always limit or take away what it's given you. And in 1977, Pennsylvania passed a statute to limit increase in wage tax for non-residents. At that time, the statute did not allow Philadelphia to raise the non-resident wage tax until the resident rate reached a certain percentage. Today, the non-resident rate can be increased, but it cannot exceed 75% of the resident rate. Apart from limitations in the non-resident portion of the wage tax, there are bills proposed at the state level aimed at amending the Sterling tax to force Philadelphia to remit non-resident wage tax revenues to jurisdictions with local taxes on earned income. Legislation that amends the Sterling Act in relation to the wage tax could have a devastating impact on the city's revenues and would force us to make some combination of painful cuts to services and increase in tax rates. So it's one of our highest legislative priorities always now is to resist those bills from suburban legislators.
Okay, so now that we've covered federal and state laws that limit our taxing power, I want to go through a few examples of some, like I said, some very well-intended legislation that unfortunately violated some of these rules. So I think that what we're trying to show here is how careful that we need to be in proposing tax legislation and always, taking into consideration what we can and cannot do. So let's get started. Can you talk us through, Francis, the 3 examples in this slide?
Right. The first would be the land value tax. A land value tax sets separate rates for land and improvements. And this goes all the way back to George Henry and a lot of history. The General Assembly has specifically and explicitly authorized most of the jurisdictions in the Commonwealth to have a land value tax. They have not authorized Philadelphia to have it. So not only is a land value tax, if you remember our discussion earlier, probably very questionable on uniformity grounds, but it is clearly not authorized statutorily for Philadelphia. And it would be immediately challenged on both those grounds in court if we were to try and pass one.
Okay.
The second example of a tax that failed was the intangible personal property tax. It's exactly what it sounds like, a tax on intangible goods, and that essentially was stocks at the time that this was done. And the Supreme Court struck down that personal property tax in 1998 because it gave more favorable treatment to stocks of Pennsylvania companies or companies that were doing business in Pennsylvania than it did to companies that had no connection with the state. And if you'll remember, the Dormant Commerce Clause of the federal Constitution specifically prohibits that kind of favoritism. Last but not least,
we were sued and we did settle that litigation, right?
We did settle that litigation. It was
right.
a long and torturous path. The tax was struck down. We enacted another tax that essentially clawed back the same amount of revenue, and then we agreed not to give them refunds and not to provide refunds and not to enforce the new tax, and just everybody went home status quo.
Okay. So the last tax
it's not a situation we want to find ourselves in again.
Absolutely not. No. So the next one, the last example is the graduated state income tax. Do you want to talk through that one?
Right. And that goes back again to the question of whether you can separate taxpayers into different classes based on how much income they have. And you probably are aware the personal income tax in Pennsylvania is a flat rate, and it has to be a flat rate. And that was determined way back in 1935 by the Pennsylvania Supreme Court, which struck down an attempt to have a graduated rate. Attempts to even use the federal definition of taxable income that would recognize whether somebody has dependents or has a mortgage or any of the other sort of tweaks to your taxable income that you have in federal income tax have also been held, that definition of taxable income has also been held to be non-uniform.
Interesting.
The only thing you could look at is sort of people's gross income. Bang.
Okay. Well, I mean, although we've spent a good amount of time talking about all of the limitations and the rules and regulations, I mean, we still have a variety of tax types. We have a variety of assistance programs. I mean, some of these guardrails exist for a reason, whether we like it or not. And we have introduced new tax types that don't violate these rules, like, for example, the upcoming development impact tax. And we've managed to use the law to help, vulnerable taxpayers and small businesses through exemptions and credits and a lot of other types of tax relief. So we're still making it work for Philadelphia, but we just have to follow the rules. And I think that for folks at home, we just need you to keep in mind that, what might feel like a small tax change, it really, even like changing due dates, that's even changing due dates to match state or federal deadlines, or changing certain communications or noticing can have a big impact on taxpayers and may or may not follow the rules set out to us by the state or the federal government. So I want to thank everyone. Francis, thank you so much for your time this morning. Really appreciate this little mini legal lesson. I feel like I could march in someplace and throw around some big words like the Sterling Act and Act 55 and the HUP test, and really sound like I know what's going on. And I hope the folks watching also feel that way too. Like I said, we're going to post copies of these slides as well as the notes, kind of the talking points from this presentation so that you can follow along. And I want to remind folks to follow us on YouTube, phila.gov. You can find our YouTube channel is youtube.com/philarevenue. And we're going to have a couple other of these videos and all of our other videos. And we hope you continue watching and following us and have a great rest of your day. Thank you.
Thank you.